court documents, subpoenas to produce documents. Get familiar with them, people. They'll be up on the
Ladies and gentlemen.
share site. Now we're going to work.
Gentlemen and ladies and gents, just want you to see something. It was there a second ago, and then I took it off. So let's bring it back just for a second. A little bit more. See this? United States Bankruptcy Court. This was a fee waiver. This was done right after I discontinued my vacation and 2 days before I started my new vacation. Because I'm telling everybody about voiding out plea agreement, not voiding out plea agreement, probation papers. That's right. If you feel you got no other choice and you got to sign a plea agreement, sign a stupid plea agreement. Then when you get released and you have to go meet with that probation officer, remember, that's a different department, different corporation, different agency. They're not part of the court. Your agreement is not with them. They are part of the so-called prosecution office, whether it be state or federal, but they are not part of it. They are a separate organization. They're a private entity, and you're making a contract with them. Okay, and you're going to be held to that contract. So, this is what I'm going to tell you so that you get it. Void the contract. There is no law requiring you to sign that contract. As a matter of fact, ladies and gentlemen, since I was talking about it, because I wasn't actually planning on doing this video, but we're going to do this video the way I said I was going to do it. Let's do right to contract. Okay, it's called the right to contract clause. Ladies and gentlemen, it is known as a fundamental right. Now, there was a gentleman, detective, no, not a detective, he was a former sheriff deputy. We're going to change from Chinese to Chinese. But anyway, he was a former sheriff deputy. And this former sheriff deputy was telling people that the Constitution doesn't give you rights. He was 100% right. The Constitution does not give you rights, people. You already have rights. The Constitution only secures those rights. Okay, fundamental. Now, here is the point. This is what you need to pay attention to. Touchscreen. Touchscreen, baby. It's just touchscreen. Okay, freedom of contract. Freedom of contract is the freedom of private or public individuals and groups, if any legal entity, to form contracts without government restrictions. This is opposed to government restrictions such as minimum wage, competition laws, and price fixing. Ladies and gentlemen, freedom of contract, the right to contract. It's a fundamental right. Nobody can take that away from you. Wait a minute, what's a fundamental human right? I thought you'd never ask. Fundamental human rights are generally regarded as sets of legal protections in the context of the legal system, where such system is itself based on the same basic fundamental and inalienable rights, such as the right thus belongs without presumption, or the cost of privilege of all human beings under such jurisdiction. Fundamental. Okay? Fundamental. Restricting the freedom of contract. A fundamental prohibition. Okay? Ladies and gentlemen, the right to contract. When you sign a plea agreement, that's one contract. The probation papers are another contract. If you're being placed into a halfway home, that's another contract. So what I instruct people, that's right, I instruct people, I give legal advice. I don't hide that. I am what's known as a non-attorney. But a competent non-attorney. I had at least 7 psychiatrists say I was a competent individual. So that means I'm a competent non-attorney. Watch this, ladies and gentlemen. You ask, why does he do that? Because he can. Okay. I was pausing to see if it already had the term in Google, but as you saw, I did not see it. Lawyers shall provide competent representation to the No, I want the whole phrase. Okay, so let's do competent non-attorney. Did you see that? The court also cited increased costs to the consumer and the existence of a robust regulatory regime and the presence of competent non-attorneys. This was 2013. Non-attorneys can modify home loans. Did you see that? South Carolina Supreme Court. Non-attorneys can modify home loans. Another, assistance of counsel writ. To deny RB aid from a competent non-attorney. Okay? This is their phrase. Sorry, y'all. Willie is calling me, and I'm going to let Willie know that I'll call him right back. Willie should have been calling me a couple of days ago. He getting on my nerves. And I purposely didn't call him because I had already told him to give me a call. Willie and we going to have some words, y'all. Okay? We gonna have some words. Well, anyway, competent non-attorneys. That is their legal term. Ladies and gentlemen, I am a competent non-attorney by rule, by law, by statute. Okay? As such, I can give legal advice. Okay, notice this. New Jersey pro se document, the anti-family courts. Okay. Mr. Blah, 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 who is unable to afford licensed counsel and is unschooled in law, to be denied assistance of a competent non-attorney. Okay, these are just individuals talking. But to show you that the courts recognize this, let's go back to the top. This is the Supreme Court for the state of Carolina. Caroline! What? Her smells like roses. Some of you are going to get that, and then some of you are going to get that. Oh, Lord. Ladies and gentlemen, modify home loans. On June 19, 2013, the South Carolina Supreme Court, let's go back, issued, stupid computer, stupid touchscreen, its long-awaited opinion in Crawford versus Central Mortgage Corporation, determining that mortgage lenders and servicers may continue to modify mortgage loans without requiring supervision by a South Carolina licensed attorney. You see, they refer to these individuals who work for a lending company as being competent non-attorneys. Under the ruling, the loan modification conducted by non-attorneys does not constitute unauthorized practice of law. Thank you. Thank you. You see, that's what they wanted because the attorneys wanted to make money off of that. But do you see how that ruling by the court, which I had not heard of before, until I looked it up today, is exactly the point. See, you can't charge somebody with the unauthorized practice of law because statutes are not law. I don't teach people statutes. I don't care about statutes. But even if I did, I don't need their permission to interpret statute. Remember, everyone is deemed to know the law. So I cannot be charged with practicing the law. The issue here is that these individuals working for these companies modifying these loans are getting paid. So the attorneys wanted to come at them for the unauthorized practice of law because they were receiving a payment. But here, notice what it says. On March 8, 2012, the court in its original jurisdiction agreed to hear oral arguments in Crawford as to whether modifying a mortgage loan without the participation of an attorney constitutes an unauthorized practice of law. I promise you, they brought up the fact that these individuals were being paid for modifying these loans, and as such, they were practicing law. Well, the Supreme Court of the state said, no, not the case. Okay, in both cases, the borrower defaulted and foreclosure actions were filed. Both borrowers sought to prevent the foreclosure and to have their loan modifications and the mortgages they modified declared void, according to the lenders engaged in the unauthorized practice of law. Arguing that the lenders engaged in unauthorized practice of law. You know what? I did not know that. That's okay, because I know that their attorneys did this. The crux of the argument being that the loan modifications had a legal effect, and it changed the legal rights of the parties by altering the interest rates and the prepayment terms. I'm glad the Supreme Court of Caroline made that decision, because it was stupid for them to say otherwise. All right, ladies and gentlemen, this is just a simple video letting some of you know we have people being charged with being, what's the word for it? Sovereign citizens. Y'all heard of that sovereign citizen movement thing? I have several people whom they have charged with being sovereign citizens. Okay? Ladies and gentlemen, you can't argue that point. You can't say, okay, because the moment you argue the point that you're not a sovereign citizen, you've now taken on the gauntlet. Now you are stuck, because you can't argue that. So this is what you do. One party accuses another one of a crime, and they furnish proof, no actual factual evidence, only misconstrued comments. Another party sits and he says, I am not what you're saying I am, and I demand you stop slandering my name, for that will make you guilty of libel and slanderous conduct, and yet they are ignored. You might think that I'm referring to sovereign citizens, but I am not. What I'm referring to is the actual communist witch hunts, or for the lack of a better illustration, the Salem witch trials. The similarities is in mankind's history. Name calling is an act by which children play. In this, it is an immature, childish way to conduct oneself. It's supposed to be immature, and I was supposed to correct that, and I didn't. Well, I'll correct it now. Uh-oh. I just deleted one letter. Waiting for it to do that, because needed to do it correctly. Ladies and gentlemen, this is immature, not immature. There is no CH in this word. It is immature and childish way to conduct oneself. The court has suggested that one is a sovereign citizen only after the opposing party suggested that one is a sovereign citizen. 2 against 1 doesn't seem fair, and I must object to this convention and unlawful gathering in unison that has been undertaken by officers of the court. Yes, the attorneys are officers of the court, and the judge is officer of the court, and the court is supposed to stand for honor, and yet the brotherhood and members of the cloth, the craft, that's right, masonry, are being demeaned by this prejudicial conduct and should be held accountable for bringing the image of the brotherhood into disrepute. Let me see if I understand this. Even if I were a sovereign citizen, is the court stating that sovereign citizens do not have a right to subpoenas? Now, that would be interesting if the court is saying that a person who is deemed by the court and or opposing party to be part of what they refer to as sovereign citizen group, organization, or movement, that they do not have due process rights and are not protected equally under law. Why, that would be interesting. To deny someone access to subpoenas would require some showing of cause for why subpoenas should not be issued. It would require a showing by either the court or the opposing party that the other party has violated some rule or some general principles by which subpoenas are governed. I do not see any such showing on the record, and am at a loss to understand the irrational rationale of the court, as it does not appear to be as any reasonable man or woman would understand, which is what the law requires. I also take it by the court's actions, that individuals who are accused of being witches, communists, sovereign citizens, and unlawful combatants do not have rights within the court systems of the United States governed by the Administrative Office of the United States Court. That appears to be very interesting because the laws within the United States do not allow any agency to discriminate against another because of religious belief, gathering affiliations, or alliances. Please understand, ladies and gentlemen, the right to gather, the right to assemble peacefully is a constitutional secured right. You cannot be segregated because someone says that you are part of a group. Whether the government says that this group is this or that, it cannot happen. It violates the laws of the United States. Let me continue. Yes, you may. Now, you can make it a point that it matters not the affiliation of many of the, and I forgot to correct that, if be they sovereign, and see, I got to get rid of that. That's what it's supposed to say. Be they sovereign or communists, that here in the U.S. all are deemed to possess due process rights, and this indeed is a presumed secured right. Honor is associated and affiliated with and adherent to fairness. Let's just go ahead. Yeah, we can leave with and affiliated with and adherent to fairness and is reasonable or just. So to say that one simply does not have the right to access government in any of its branches, the right to be sued, a paradox and a new venture of a wayward magistrate judge of a district court who has or seems to be suggesting that in order to communicate with the court or with regards to the respondent's motion or the court orders or make a statement that one needs to ask permission to rebut that statement, such presumptive statement, rebut that statement. Sorry. Sorry, I was doing texting, I mean not texting, but voice text recognition in my cell phone. The court suggests that we presented to the court our presentments in direct opposition to the opposing party, as each of our responses and rebuttals and or orders let's see. Give me where my mouse at. Where my mouse at? Okay, was directly related to the orders and responses by the court and the opposing party, as per article, and not a maxim of law, but a theory. One must rebut a presumption, as the petitioner has done. Otherwise, it would foreclose an opportunity for the petitioner from challenging evidence entered into the record in the courts of the U.S. And I cannot see the rationale of the court through the wayward magistrate. The right to recuse a magistrate. See, you don't have to be before a magistrate in federal district court. Now, the reason why most people elect to have a magistrate, because with a magistrate, the case goes by a little bit faster. Without a magistrate, the hearing dates are longer, set apart, and it takes longer. Well, ladies and gentlemen, if you are being put through civil trial, let it take longer. If they are trying to mount something against you and cause you problems, let it take longer. Go before the judge. Let that judge sit up there and issue their so-called orders and just respond to the orders.
You don't have to use case law. Ladies and gentlemen, all that I've said in here is from case law, but you will not see case law put in this document. You might see one statute or something or another, but in this 50-some point document, you do not see no case law. Why? Why didn't he put case law? Well, you did put case law. You put case law at number 1. That's very one. You put case law right there. See? Case law. It's the Judiciary Act of 1789. That's the only one in a 8-page presentment. Why? Why did you only do that? You could have just sat up there and just killed the whole nation. Ladies and gentlemen, because I don't need to tell the stupid court what the law is. They are deemed to know the law. From the Space Shuttle Columbia. Ladies and gentlemen, I was in school when that space shuttle just decided to explode in midair. And I don't think it was an accident. I think it was done on purpose. That's right. Remember, go back. There was a teacher on board. Had all the children, everybody watching. You guys remember that? Those of you who were in school at that time, especially in elementary school, TVs were on in the school. All the teachers were promoting it. The nation was promoting this. The news was promoting this. And then it explodes in front of the eyes of all the little children. All the little children. That was done on purpose. People say, why? Why was it? Well, first, NASA needed more money. And second, they needed to do the shock and awe. Remember, that was right about 1984 that it happened. Go back. Don't you remember that idiot Alex Jones talks about 1984 all the time? Okay? Just want you to just start putting pieces together. Do I have all the answers as to why the space shuttle exploded? I know it wasn't due to no stupid O-rings. Okay, that's NASA. They have backups upon backups upon backups, so that if one system fails, there's a backup system. And with that much rocket fuel and that much heat, you and I both know that it wasn't a result of some O-ring. Well, the O-ring fell, and because the O-ring fell, the ovaries did not connect correctly, and so that the baby was born deformed. Ladies and gentlemen, that's how stupid that was. All right, this is not going to be a long video. What we wanted to do, first of all, we wanted to let you know about those of you who are dealing with the federal government, those of you who are dealing with federal custody issues. Remember, if you've signed a plea agreement, that is a contract. You can, at any time, change the terms of the contract by putting in a notice of change in terms of contract. But if you do that, you're going to have to do the research first. Ladies and gentlemen, if you do that, you're going to have to do the research first. You see, that's been the problem. I'll say this or I'll say that, and people will immediately jump up, figure they know what I'm talking about, and they go out there and try to start doing. It don't work like that. Life don't work like that, man. Hades doesn't even work like that. So stop being so impatient. That's where you're getting hurt. Oh, ladies and gentlemen, yesterday I went and I downloaded a lot of videos, older videos that were up on redressright.org. And what I've done is I've loaded these videos here. And we will be loading them up to the internet so that y'all will have access to these videos. They'll be up. Then we'll be putting up some of the other videos. So by the time we get finished, there'll be about 300 to 400 videos up on this site. Okay? This will make it almost 200 videos, and I'll be adding about 200 more. So just y'all stay tuned, stay tuned, stay tuned. And these will all say in the description, re-uploads. The title may have changed. Okay? This will be on the EEON 1 YouTube channel. EEON Uno. Not EEON 2. EEON 1. Okay? Alright, ladies and gentlemen, giving you guys that information about signing your probation papers, if you're in the situation where you are being sent to a halfway home or you know somebody who's about to be released from jail, either on probation or parole, remember, each of those agencies, the parole board, parole agency, the probation department, and by all means, if you have a problem, tell them you listen to this video and this is what I said. Okay? I ain't got no problem with that. Okay? I ain't got no problem standing by what I've already done. Remember, I did it before anyone. I didn't just tell people to start doing it. I did it first. Yeah, they got mad at me. But they didn't get mad at me and say you violated probation. After I voided out the probation papers, federal, they put me on vacation again for 15 more months, but at no time did I go before a federal court regarding probation violation, which was automatic. The probation officer petitioned the federal court, demanding that they violate me, because I had told them already I voided out the papers, and the federal judge, I put the paper up there, I showed it to y'all, the federal judge said the case is closed. There will be no hearing. Why? Because there was no contract. I had no obligation. Do you get it? I had no obligation. I had already received quote-unquote time served in their kangaroo court, and the judge ordered 2 years probation. So I simply wrote void. I didn't write it in big, huge letters. I just signed my name, and every time I wrote my initials, I put void next to my initials. It's okay. They can get mad. They can say, no, you can't do it that way. Ladies and gentlemen, you have the fundamental right to contract. The only thing the court order requires you to do is sign that contract. However, you can void out that contract at the point of your signature, or guess what you can do? You can void out the contract later, but you have to do the research on how to void out a contract once it's been entered into. There are specific guidelines for that. It's called contract law. The Uniform Commercial Code should be one of the sources of your research, since that is what I referred to in the past as contract law. Okay, ladies and gentlemen, keeping this short, wanted to bring this to your attention, and we are going to do the best we can to provide information when you need, how you need, and where you need it. Okay, I got a lot of things going on, but I just wanted to take the time to do this real quick, and then, as we said at the end of this video, it is absolutely necessary for those of you who are being accused of being sovereign citizens. Ladies and gentlemen, they tried to accuse me of being a sovereign citizen. I told them, okay, prove it. I'm not going to do an Osama bin Laden. Oh yeah, I didn't do that. And he said it for 7 months, he didn't do it, and all of a sudden, okay, I did it. Excuse me, please. You ain't going to get that from me. You can sit up there and say whatever you want to about me, but I promise you, you can't prove it. Like I did the video yesterday, showing how some people said that I've been scamming people in 2013, said I was a scammer. In 2013, no proof, not one single example that they bring up, but they said it. Ladies and gentlemen, I've been talked about all my life. Discriminated against. Hated. Okay? It's okay. I don't care. I'm trying to think of the song where the person talks about I've been this and that and discriminated against, and I can't think of the song because it's in my head. But let me let you all know this so that you get it. Let them say what they want to about you. You simply say, well, you're saying this, and so I simply say, I am not anything of what you just said. So now the burden falls upon you, or shifts to you, to prove your point, because I've just rebutted your presumption. So now, please provide the proof. If not, I will sue you for libel and slander, and you can do this with the so-called Department of Justice and the FBI, because these are the people who are mostly making these comments. Ladies and gentlemen, because I make a statement Because I say something that somebody else in some other group has said, that does not make me affiliated with them or make me a part of them. For you know why? Do you know what the number one thing about sovereign, the people are sovereign? Notice this. I put the sovereignty resides in the people. Okay, that's all I did. Sovereignty resides in the people, and all government authority emanates from them. Okay, let's go here. Okay, is this one of those sovereignty websites? I don't know, and I don't care. What I'm looking for, hold on, wait a minute. This one doesn't give it to me. Nope, this one doesn't give it to me. I'm looking for the case law. Neutralize the Supreme Court. Nope, not there. I am looking not for somebody's opinion, because that's what this is. This is just somebody's opinion. I don't care about opinion. I'm looking, the sovereignty resides in the people. Thus, categorically speaking, the Constitution of the Republic of the Philippines. Well, every nation, every constitution says that the sovereignty resides in the people. Okay? Puerto Rico's constitution says it 7 times. No, 3 times. Sorry, 3 times. I don't know why I'm saying 7. Because of that right there. 87. Okay? Popular sovereignty. No, sovereignty in the people. The Philippines. You know what? I can't do sovereignty resides in the people because the Philippine document says the same thing. Okay. No, we can't do the Philippines because that's the way their constitution reads. And guess who wrote their constitution? Okay, I'm just going to put the sovereignty is in the people. Okay? Just that simple. Popular sovereignty, and the sovereignty is in the people rule. It's the principal authority of a state, and its government is created to sustain blah, 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 blah. I need the actual, this is Wikipedia. Okay, we can do the sovereignty of the people. At the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. That's 1215.org. That's Billy Bob Thornton. William Thornton. Sovereignty of the people, roundtable. The sovereignty of the people, roundtable. No. Sovereignty, people sovereignty. No, I'm looking for the actual case law. Ladies and gentlemen, I'm not finding the case law. You know what? The very idea of popular sovereignty. Doctrine that the people are or ought to be sovereigns is misleading. And yeah, now they say doctrine. I don't want to do doctrine. I want to do the actual case law. Okay? Yeah, we can do limited government, but that's what I don't want. Watch this. Then, popular sovereignty, or the sovereignty of the people rule. The sovereignty of the people rule? Basically, ruled by the people, for the people. Remember, the U.S. is supposed to be a government of the people, for the people, by the people. Case law. You'll see why I'm doing this. There's a reason why I'm doing this. Okay, sovereign power, and as the government proceeds directly from the people, okay, and is ordained and established in the name of the people, and is declared to be ordained. The sovereignty is in the people. Now, that is why sovereign citizens lose in court. because they go in talking about they are sovereign citizens. There's no such thing as a sovereign citizen. However, there is a such thing as the people as a whole are sovereign. Okay? The people as a whole are sovereign. So, what does this mean? This means simply this, ladies and gentlemen. Since the people are, as a whole, in our country, the people are sovereign. Since the people as a whole are sovereign, the courts have said it. So, can there be a such thing as a sovereign citizen? Well, here is what the courts have done. They have taken sovereign citizen and have attached to it a term, monology, a meaning, a name. What you have to do is you have to dispel that. Well, say the Supreme Court are the ones who said it. Okay, and you find Supreme Court cases where the Supreme Court actually stated that, where that was the actual intent of government, that the people, the sovereignty resides in the people. Okay, because there are several cases that say that. Okay, here is the point. If the Supreme Court said that sovereignty resides in the people, then guess what? The Supreme Court were sovereign citizens. So you would be in a pretty good group, huh? Then the Supreme Court were terrorists. You would be in a pretty good group. Go ahead and look and see if you find any cases from the United States Supreme Court on sovereign citizens. Only from the district courts do you hear this, and the Supreme Court has not had a single case. Now, the person in this case cited Chisholm versus Georgia, okay? And it says the court found that it had jurisdiction to hear the case. Why did the court find it had jurisdiction? Because the person, I was watching a video on RT about sovereign citizens, and the expert sovereign citizen Alfred Adesk was explaining why people are sovereign. He cited this case and the court found it had jurisdiction. Okay, this is, again, somebody giving their opinion as opposed to going to the case law for the opinion. Okay? Now, finally, one of the arguments that we brought up in the document that I just showed you is gotta separate. Anytime the United States enters into commercial business, it abandons its sovereign capacity. Okay? Watch this. Anytime the United States, I've shown this to you on video way too many times, pay attention. Appeal from the United States District Court for the Western District of Oklahoma in 1916. When the United States enters into this commercial business, it abandons its sovereign capacity and is to be treated as any other corporation. Ladies and gentlemen, this is fundamental law. Here's another case. United States as lessor of 15 premises located in Southwest entered into ordinary commercial transaction, abandoning any sovereign immunity and thereby coming within the business relation exception of the general rule due government. The United States is acting as in its sovereign capacity and its blah, blah, blah. This, I would definitely tell you, you need to look up. Why? Why is this? Well, because anytime the United States enters, and you do, Shermalot versus Cherokee Nation Distributors Incorporated, okay? Shermalot, United States Court of Appeals, 10th Circuit, Colorado, Oklahoma, New Mexico. This is their circuit. Okay? Ladies and gentlemen, you want to pull this case because this is a long-standing case, and the principle of anytime the United States enters into commercial business, it abandons its sovereign capacity and is to be treated as any other ordinary corporation. So, guess what? All the courts are corporations. They engage in commercial business activity all the time, i.e., willfully abandoning their sovereign capacity and voluntarily agreeing to be sued. They have no immunity. I'm looking for it now, but we're not going to spend a lot of time because I want to go ahead and let you guys get back to your lives. I just wanted to bring this up to give some of you who are going through some court issues some ideas, some things that you need to be doing research on so that you can speak up and defend yourselves. People are saying, well, now just tell me how to get out of jail. Well, first of all, you got yourself in that situation. You should have already done this research before you got in that situation. I've been able to help people get out of jail because I bring up these points. Okay? Now, let's do this. Uh-oh. My voice just faded away for a second. Oh, no. Some people... Well, anyway, each limited liability company may be sued or be sued, complain or defend in all courts. Ladies and gentlemen, please understand, when the United States voluntarily abandons its sovereignty, it volunteers to sue or be sued. Okay? The approach is consistent with traditional treatment of sovereign immunity of the United States. Okay? Tribal sovereign immunity is deemed to be coexistent with the sovereign immunity of the United States. Okay? Now, they're letting you know that's what they're talking about, the United States sovereign immunity. And remember, we're doing this law, this principle, this fundamental principle. Pay attention. Here it is right here. Salas, this is the case you want to look up. It's not the only one. Okay? Because you have these cases are the cases you want to look up. Let's highlight it. Let's bring it up so you can copy it. I know you can see it because I can see it. Matter of fact, I made it too big. Let's get that. Uh-oh, made it way too big. Okay? Citing Bank of the United States versus Planters, Bank of Georgia, 22 U.S. 904, 907, 908, 1824. Now, focus right there. Planters Peanuts. Anyway, Planters Bank. Anyway, probably Planters Peanuts too if you do the research. Salas versus United States. It's 234 Federal dot 842, 844, 845. Second Circuit, 1916. When the United States enters into commercial business, it abandons willfully its sovereign capacity. That means it says that we are electing to be sued. That's what it means by it abandons that. It is saying we want to be sued, you can sue us, because we don't have any sovereign immunity. It abandons its sovereign capacity and is to be treated like any other corporation. Notice this. Pay attention. Those of you who are in federal court or state court, the court can identify no reason to depart from this principle. Okay? The court can identify no reason to depart from this principle. Fundamental. Principle. Fundamental. Okay? Then it says Panama, and it talks about courts held corporation was distinct from the United States and did not share in its immunity. Okay? But then they say that this case was citing these cases. One is 1919, 1916, and guess what? Let's do that. We are copying that, and we're going to put it in this document right here. Come on now. Pasty. Just, uh-oh. Well, that, you know what? This is it. We're going to do United States enters into commercial business, it abandons. That's going to be the title.
TikTok copy. Save.
Okay? So, but what are you saying with all of this? We don't understand. Okay, so in 5 minutes, we're going to break it down. Ladies and gentlemen, United States is a corporation. Many of you already know this. Do not cite that Title 28 subsection of the U.S. Code, Title 28, subsection 3002 at 15. Do not cite that. That's only the federal, Act. Do not cite that. I'm sorry, I saved this under the wrong name. Save as. And we just go paste and save. Okay. All right. Since the United States is a corporation, they file what's called CAFR, Comprehensive Annual Financial Reports. In the Comprehensive Financial Reports, as Clint Richardson explained in his video, Corporate Nation, the government filing Comprehensive Annual Financial Reports, or CAFRs, in the Notes Reference Ledger section of the Comprehensive Annual Financial Report, and that's what you have to seek from the Office of Accounting or General Accounting Office. And when you get that, you will see that the government not only pays taxes, but they make a profit that doesn't go to the people. They are conducting commercial business. Remember, the CAFRs prove that they conduct commercial business. The CAFRs for the court proves that it conducts commercial business. The courts do not represent the judicial branch of government. They represent the executive branch. They are a private agency because their CAFRs show that they conduct commercial business. They're trading in bonds, people. I bring up the fact that I'm going to bring this information before a jury. I tell them I demand a jury trial. I don't say, and if you give me a jury trial and you don't want me to say this, you better offer me a plea. I don't say nothing to them like that. I just let them know I'm going to expose your system to the jury. You want to play? I want to play. And I do this every single time. I do not mince my words. When I get subpoenas, I'm bringing this point up every single time. You fools want to claim that somebody's a sovereign citizen? Well, then that means the Supreme Court is a sovereign citizen too, because the courts have consistently said that this principle is etched in stone, that whenever the United States enters into commercial business, it abandons its sovereign capacity, which means it is no longer government. Because government cannot stand in any other capacity but sovereign. If it ain't sovereign, it ain't government. This is what we know. This is what we bring up. You people who are in trial now, you people who have got counts against you, you people who have got suits against you, you people who have got traffic tickets. Ladies and gentlemen, this is the point you need to be bringing up. And you need to be seeking your subpoenas to pull their comprehensive annual financial reports and any other financial records to prove that they engage in commercial business activity, even during any part or course of your trial, your matter. Why? Because that means that they're not government, which means that the hearings are illegal because they're not under the judicial branch of government, which means that they don't have any jurisdiction over you without your consent, and you simply don't consent. They cannot get around this. They have not gotten around this with me. The only thing they have done is dismiss cases. That's what happened in Puerto Rico, because I told them, you fools want to play, I want to play. Let's go to trial. And I will present this information to the jury, and you don't give me my subpoenas, and they've never given me a single subpoena.
You don't give me my subpoenas, I'm going to let the jury know that you denied me that fundamental right, because in all criminal proceedings, an individual has the right to subpoenas. That's what I do. That's how they leave me alone, because I let them know I'm going to do this to them. That's why I'm not afraid of them or their system. You want to play? I want to play. I will eat you alive from inside. Like Mike Tyson said, I will eat your children alive. Sorry, I ain't Mike Tyson, and I would never tell somebody that. Sorry, I probably would never tell somebody that.
Ladies and gentlemen, that's my 5 minutes. I said I was going to take 5 minutes to explain it to you. That's 5 minutes of explaining to you that the United States is not government when it engages in commercial business activity. So, have a very good day, everyone. I hope this information is of some benefit to some of you. Please do not text me and write me. Do your research on these points right here. You want to make your foreclosure go away? Bring this point up in that court. When that court starts to turn against you, ignore your arguments. Bring this point up so that you'll have a point in appeal. Okay, that's why we've been winning the appeals. That's why they've been sending the cases back. Because I keep bringing this point up. You want to play? I want to play. That's what my success has been in the last couple of years. That's why so many plea agreements in Puerto Rico, over 35 of them, the time was reduced by more than half. Okay? That's why at least 6 people got released from jail in Puerto Rico because I brought this up. That's why
we got 17 of these affidavits sitting on my desk and I don't know what to do with it.
The so-called Attorney General for the state of Puerto Rico, or island of Puerto Rico, or Commonwealth of Puerto Rico, was saying when we were doing affidavits, and please don't stop doing affidavits, they worked. Please don't stop doing affidavits, they worked. You don't need it to be notarized. An affidavit does not have to be notarized, it just needs your signature. And you attesting that the information is true and accurate. And you don't have to say it's true, you just have to say it's accurate. You don't have to say to the best of your knowledge, you just have to say it's accurate, because accurate does not mean that it's 100% correct. It just means that it's as close to correct as it's going to be. Just that simple. Ladies and gentlemen,
but you have so much knowledge and it's just so much information.
Then you wonder why the videos are so long, because it is so much information. Okay? This is what I've been trying to get across to certain people. I've been in federal, I've been in state, in their jail systems. Okay? I have tested them out.
But you're a scammer, that's why you were there.
I certainly did scam everybody. I scammed the whole system. Went to jail and scammed the whole system while I was in jail, and I'm still scamming. That is amazing that idiots could speak about me without any proof. And of course, there are going to be some ignorant mother out there that's going to, I got proof! And I won't be able to be in the same room with that person because I may lose my religion and really give them something to put me in jail for life for, or give me the death penalty for. Certain things I can handle, but certain things I can't. So I stay away from it. And that type of ignorance, I stay away from. Those type of ignorant people, I stay away from. Have an issue with anger that I'm still working on and have been working on for years. Over 30 years I've been working on anger. Just because I'm working on it doesn't mean I perfected control. Everybody else says that I have a lot of self-control. But there's some ignorance out there, like Ron West. You see, I can't be in the same room with that person because I probably will put my hands on him. And I know what I'm capable of, so I have to stay away from that ignorant, stupid... Sorry. Let's get back to any time the United States engages in commercial business. Ladies and gentlemen, the United States, including the Department of Defense, engages in commercial business all the time. All of the time. This means they are not government. If they are not government, then who are they? That means they don't have any jurisdiction because they don't represent government, which means they're blocking your access to government. And people, you need to start recognize this and start challenging on this point right here. This point right here. Okay? You guys just don't have any idea of how powerful this phrase right here. Whenever the United States enters into commercial business, it abandons its sovereign capacity. That is the point, because they're always engaging in commercial business activity. The courts are trading in bonds. The court's actual judge pension is based on bond trades and trading on the financial markets. They have an active interest, which means that they are engaging in commercial business because oftentimes the court in which you are with your foreclosure are invested in the very same mortgage-backed securities that are standing before them that day. And nobody challenges them on that. Well, we are. In all of our pleadings and all of our motions to the court that are in court with foreclosure, we're bringing up the fact that the actual judge or the court is invested in that so-called mortgage-backed securities or associated with investments with that particular mortgage company that's coming in there claiming that that person owes a debt. And by the way, if you don't have a letter from the FHA, you can't foreclose on my house.
Well, we don't need a letter.
Then you need to prove you don't need a letter because the FHA Act says you do need a letter from the secretary. That's all you have to say, people. You don't have to be a rocket science. You know what? 5 more minutes, okay? Well, 4 more minutes. Just 4 more minutes. We're going to take it to an hour. 4 more minutes, all right? I was speaking with a lady today. She said, look, you gave me this response to give to the bankruptcy court because they dismissed my bankruptcy because they didn't like the fact that I was filing as a non-individual, even though they accepted the fact I was filing as a non-individual because they dismissed it because the clerk didn't like it and didn't send me no papers, and then they claim I purposely failed to attend the creditors meeting. But then you wrote that I came in as a creditor and as the counsel for the entity, and so they had to send me a letter not only as a creditor, but also if they claim I was a debtor, they had to send me a letter as a debtor. And they said, okay, fine, case gonna continue, we're not dismissing it. And then the judge gets mad and says, well, this person's filed over 8 bankruptcies in the past 10 years. Told him, sorry, that's not enough. There's a means test. Congress has instituted a means test, and that wasn't applied here, so you can't dismiss this. So you need to reconsider your actions. Oh, and in the meantime, well, she says, look, you wrote that for me, and I'm getting ready to file it. Do I send this to the other party? And I told her, you just answered your own question. Because she said, because they sent the copy to them of the dismissal, or the denial, so I figured I have to send it too. I said, you just answered your own question. Why are you asking me something you already know the answer to? She said, they sent it to them, so I think I have to send it to them. She just answered her own question. Then I told her, I said, you were supposed to go over the basic rules of the court. I said, that's what happens when you work with me. I don't do all the research for you. You do some of the research so that you'll have a little bit of knowledge as to what's going on. So you don't have to ask me the most basic and most simple of all the questions. Then I told her, I said, now look, young lady, you ain't bothering me. Because she says, well, I'm sorry for bothering you. You ain't bothering me. I said, you're disturbing me. Because you are probably the smartest person you know when it comes to any of this information. None of your friends know more about this than you do. She says, you're right. I said, so if that is the case, why is it that you sit up here and doubt yourself? That you don't know what you already know? That you haven't already done the research on most of this? Well, no, I said, that's my problem. You know this information, but you're acting as if you don't know. I said, stop doubting yourself. Ladies and gentlemen, that is the problem with us. We know something, and then the next thing you know, we go in front of these so-called people, because that's all they are. The judge is just a person. And stop telling people you ain't a person. You are a person. You are what's called a natural person. God, you're not a member of the public. That's what you don't want to be, is a member of the public. I'm a private citizen, not a public citizen. Congress controls the public citizen. Congress controls the public. So you don't want to be associated with the public. So stop associating yourself with the public. Well, anyway, ladies and gentlemen, what you want to do, is you want to start standing up. You want to start speaking on your knowledge. You want to start showing that you have confidence. Stop walking with your head down. Stop walking with your heads down. Don't walk with it up in the air. Walk with it straight ahead, level. I promise you, you'll feel a lot better, you'll speak a lot better, and people will respect you a lot more. Stop walking with your heads down. Hold your head up, not high, but hold it up and straight. And people will treat you with the respect you deserve because you deserve that respect. Why? Because you are a person. You are a person. Goodbye, everyone.